we will introduce to you Bill Blasser from Blasser Law. He's an attorney, a family law attorney, and estate planning attorney with his wife, Lisa. I had the joy of getting to know Bill actually from a connection I got with Mike Hardy, who's on the call from Churchill Mortgage, and Marilyn Sparks, who I also get to work alongside with Farmers Insurance. And Bill has just been a fun new alliance for us, and we just love getting to know him. Adrian and I, my partner in crime up there, we had lunch with Bill a couple months ago, and it just feels good to have somebody local who, this is a big need that we have in the industry of our own database and our own friends and family, those of you that have joined the call. And so we want to just bring some information about getting your home in a trust, the differences between a trust and a will, and all the things Bill's going to teach us today. Again, we'll send you the recording, and then at the end, we'll have about 10 to 15 minutes to ask him questions. So feel free to put those in the chat. I'm happy to read those off, or at the end, you can chime in as we go forward. And looks like everybody's pretty much got their mics off, but if you have any background noise and you have your mic on, feel free to turn that off for us. That'd be helpful. Without further ado, I'll turn it over to Bill, and we'll start learning some pretty important stuff. Thanks, Bill, for joining us today.
Of course. Thanks for having me. So I wanted to basically just introduce myself. I'm Bill Blasser, and I have a law firm in Claremont. We do primarily family law, things like divorce and separation and custody issues. But the other side of our practice is estate planning, which is wills, trusts, and durable powers of attorney and healthcare directives. And the theme of this presentation is more about, okay, why you should have your home in a living trust or in a will, the importance of estate planning when it comes to having a home. And I guess I'll just start with the biggest question, which is, why should anybody even do this at all? Why not just not have an estate plan, period, and let things play out on their own? And the reason for that is things kind of tend to go haywire after people pass away. And I've seen example after example of unfortunate situations where somebody has a home or more than one home sometimes, and the kids seem to be getting along as far as their parents know, usually because the kids don't want to let the parents know that they're not getting along. And after they pass away, there's no parents to worry about being polite in front of anymore. So the kids all just start fighting with one another about, what do we do with mom's house? What do we do with dad's house? And that's normally where it starts. And if there's no will or trust in place that directs how the property is supposed to be disposed of or who it's supposed to go to, then it's sort of a free-for-all where each child or each closest relative can go to the probate court and basically assert a claim. And that's where you hear the term probate come up. Probate is just a fancy name for estate court, will court, trust court, really will courts, because the purpose of trusts, I'll get into, trust will keep you out of probate. But if you don't have an estate plan in place and you end up in a situation where you have kids or relatives who are asserting competing claims to your property, your estate will get sent into probate. And while your estate is in the probate system, nothing will happen to it. Basically, all of your property will remain in a holding pattern. And right now, that would be problematic because there are a lot of people who are wanting to sell their homes before interest rates go up more. Right now, I'm hearing from a lot of people that it's a pretty good time to sell, but there's a lot of uncertainty as far as, is it going to be a great time to sell 6 months from now? It might not be. So if you have your house and it's not in an estate plan and it goes into the probate system, basically your house would just be frozen in time and nothing would happen until the court actually processes the entire probate case, which right now takes at least a year and a half, usually a little bit longer if people are fighting over things. That's just because the court is so backed up with probate claims. So if there are a lot of people right now who would probably like to sell the house that's in an estate so they can split it up, get the most value out of it that they can, but because they're in probate, they can't. They basically are forced to just sit and wait until the probate case closes up, and then they can figure out what to do, assuming the probate court lets them sell it. And all of this can be really easily avoided by putting together a very simple estate plan, which is either a will or a trust. And then there are two other collateral documents that accompany the trust or the will, and that is a durable power of attorney for asset and debt management, and then a healthcare directive. So the next thing I want to discuss is the difference between a will or a trust. If you have a will, it's better than having nothing at all, because at least when you pass away, the court will know, the probate court will know what you want to have done with your house. So basically, after you have a will, the will then be submitted to the probate court. It won't skip probate, but when it goes to the probate court, it'll probably be a much quicker process. It'll probably take at least a year, but at least you won't have as many fights as you otherwise would have if nothing else were in place. Because the will, at the very minimum, will direct the probate court on how to distribute your property. Basically, your will is going to operate as sort of like a grocery list that is going to appoint an executor who is sort of like the shopper. And the executor is going to take your grocery list in the will and just pass out all of the items in your will to the people on the list. That's it. It sounds simple. It's not as simple as it sounds, because it takes you, like I said, it takes usually about a year to get through even a simple probate case where you have a will that there really is nothing to contest about. And that's just because there are so many cases that are backlogged in the probate court. The other part of probate court that doesn't really make a lot of sense for people to go the route of a will is you have to pay for it. Usually you have to pay for an attorney to actually guide you through the entire probate process so that you know how to introduce evidence. You know how to actually get the will in front of the judge. And if you do that, you have to actually pay the attorney. And the attorney gets paid a portion of, it's a percentage of the value of your estate. So at the very minimum, you're going to be paying 4%. 4% of the value of your estate. And if it's a home, 4% of the fair market value of that home is going to go to the attorney who gets your estate through the probate system. You can avoid probate entirely, not pay an attorney the 4%, and not have to wait in line for the probate system by creating what's called a living trust. The most common living trust that I create for people is it's called a revocable living trust. So usually a person or a married couple will come in, will set up the living trust. The living trust appoints a trustee. The trustee is the person who is going to take your home and whatever other assets that you have. And when the last living spouse passes away, the trustee is going to distribute the property according to the terms of the trust. Now, there are some steps that the trustee has to take to distribute the trust, such as sending out notice to all the beneficiaries, sending out potential notice to other relatives who may have been disinherited. But you don't have to go through probate. Typical waiting period is you have to send out notice. You wait about 90 days. People can submit disputes if they have them. Usually they don't, but if they do, even if they have disputes, you can continue distributing the property outside of the probate system. So the difference between setting up a trust and doing it through a will is With a trust, you're going to wait maybe 90 days. With a will, you're going to go through probate and wait at least a year and a half. That's the first benefit. The second benefit is if you set up a trust, you don't have to pay 4% of your estate to an attorney. Most attorneys, there are lots of law firms out there, and you don't even have to pay a law firm to help administer the trust. Because a lot of people, when you appoint them as trustees, they're willing to be the trustee and do things, but they don't know how to go about doing it. They don't know how to go about sending the notices and things like that out. So a lot of times the trustees will go and hire a law firm or hire an outside party to help them actually distribute everything. There are law firms that do it usually on an hourly rate of anywhere from $100 to $300 an hour. There are also non-lawyers who will help guide trustees through the process of administering the trust. Banks, there are some banks that do it. And whatever they charge, it's a heck of a lot less than 4% of the value of your estate. It's a way less than that, and it's way quicker. And the catch with a trust is if you set up the trust is like a legal fiction. It's like its own entity. So when you create the trust becomes its own thing, like a corporation or another person. If you want the trust to distribute your home or any other property, you have to transfer title of your home into the name of the living trust that you create. At that point, the living trust will then own the property. Now, that's the part about living trusts that initially will freak a lot of people out, because they're transferring it out of their name and they're transferring into the name of this random trust. The thing is, it's not a big deal, because the trust that you write defines how the property is to be used. And when we create the living trusts for our clients, number one, they're revocable. So if our clients ever change their mind and they don't want to have a living trust anymore, or they want to just own the property themselves, they can just cancel the trust. Or if there are terms in the trust that they want to change a year or two later, they can just change those terms. So it's totally revocable, totally amendable. The first trustee for the trust are typically the people who own the property. So if a husband and a wife come into my office, they own property together, they create a trust, the first trustees in the trust are going to be the husband and the wife who create it. The first beneficiaries in the trust are going to be the husband and the wife who create it. And the purpose of the trust is going to be to provide for the health, welfare, comfort, and well-being of the beneficiaries, which is a really long-winded way of saying you can use the house and all of the property that you put into the trust just like you use it now. You can do whatever you want with it. You can sell the house, you can refinance the house, whatever you want to do that you can do right now, you can do once you put the property into a trust. The only difference is title to the trust is going to be held in the name of that trust instead of, John and Jane as a married couple with community property. That's going to be the only difference. So it makes sense for most people to set up a revocable living trust and go that route, because the living trust will let you distribute your real estate exactly the way you want to distribute it, and you'll be able to skip the whole probate process. Two collateral documents that always accompany living trusts are, one is a durable power of attorney for asset management, and the other is a healthcare directive. And these are important for really big reasons. And I had a case recently where this older couple had kids, and they had 4 kids. 2 of their kids were off on their own, doing their own thing. One of their kids was sort of taking a long time to get out of the home. He's like 38, still living at home. And then the 4th was a good guy, but he unfortunately fell into a situation where he became an alcoholic and had some drug dependency issues. And long story short, son number 3 and son number 4 were squatting in parents' house, and they didn't want to leave. They just wouldn't leave. Fortunately, in that case, the mother had enough foresight to appoint her daughter as the power of attorney to handle all of her property issues, debt issues, and her healthcare decisions. I say fortunately she did that because mom had dementia issues and essentially lacks capacity at this point. So you had the mother living in the home along with her longtime not husband, but the person she had been living with forever. Everybody considered this guy to be the father. And her 2 boys were taking advantage of her and basically trying to kick out the stepfather, who was taking care of this lady her entire life. And because she had enough foresight before she had dementia to appoint her daughter, her attorney in fact, her daughter was able to step in and kind of take the reins of the situation and file legal paperwork necessary to restrain the alcoholic son from the mother and get him out of the house and restore peace and quiet for her mother, and set a situation up where her mom still gets to see her son, but her son has rules. He can't show up drunk, he can't show up on drugs or anything like that. Now her mother set up the power of attorney so her daughter had it, but she also set it up maybe about 15 years ago before her son had fallen into the alcoholism and the drug addiction. So she hadn't revised it since then. And at the time she set it up, even though her daughter right now is the attorney in fact, her son with the drug dependency issue is the backup. So we're all kind of holding our breath, hoping that her daughter, nothing happens to her daughter, because then her son's going to have to take over. But that just underlines the importance of, when I meet with my clients, we usually set up a living trust. We set up the attorney in fact documents, the 2 documents for someone to handle debts and pay bills and handle healthcare decisions. And then we review that with our clients at least once every couple years or more to make sure that everything still makes sense, so that everything is updated and that there's nothing like that, the current case I just mentioned. Hopefully you won't be in a situation where you have a backup trustee or a backup attorney in fact who really isn't capable of serving that role, or if they did, would really, really screw things up. So that was basically, that covers the gamut of what I wanted to discuss as far as, what a living trust is, why you should have it, especially when it comes to property management. But I guess one other thing is, I think I kind of covered this before, but the main hangup I've noticed with a lot of people about picking a trust versus a will is transferring the property, transferring title of the property into the trust. It freaks a lot of people out. My grandmother, for instance, she never set up a trust because she just did not want the property to not be in her name. So she went through and had it done by a will. But again, there's really no difference. It just doesn't make a lot of sense to me for people to go with a will instead of a trust. A will is just going to take longer and cost more. So with that, I'd just like to open the floor to any questions.
I put a couple questions in the chat just so I wouldn't forget them.
Got it.
Go for it, Charlene. Or do you want me to read them?
Oh, I see
You
it.
can read
I
them.
see it.
Go ahead, Sarah.
Yeah.
You see them, Bill?
I see them. Yeah. So the first question is how does the trust owning the home affect taxes of the actual homeowner, or if you want to refinance? The trust owning the home is not going to affect the taxes.
Okay.
Basically, you're going to pay the same taxes that you would otherwise pay. There are ways to structure trusts to eliminate or limit taxes. I don't typically do those though. And if you want tax benefits for your trust, you normally have to set them up in a way where the trust is irrevocable.
Gotcha.
So
Okay.
you set it up, and the reason you're getting that tax break is because you don't own the property anymore.
Gotcha.
You've put it in the trust, it's irrevocable. And so normally what ends up happening is the beneficiary who is eventually going to get the property, they don't have to pay taxes on the trust because it's not theirs yet until the trust says it's theirs. But the trust itself will be the one who pays the taxes. Which
so is there a step up in basis? Just to make sure I understand.
What's that?
Is there a step up in basis when the property is transferred to a trust, or the basis remains the same as the individual that owned it?
It's going to stay the same.
Cool.
If it's a typical revocable living trust, your taxes are going to stay the same. And it won't, even when you file the deed, you're going to put on the deed that you're transferring the property out of the name it's in right now into a living trust where the current owners are the settlers and the beneficiaries. And then that lets the state know there doesn't need to be another assessment. The taxes aren't going to change, but you're not going to get hit with another assessment or anything like that when you transfer it. Does that make sense?
Yes, it does. Thank you.
Yeah.
How does that work, Bill, when how does that work vis-a-vis the mortgage company?
What you can be a little bit more specific? The mortgage company?
Yeah. So you're paying your mortgage company, right? And it's in your name.
Yeah.
And then is there any special the attorney handles contacting the mortgage company and telling them it's now in a trust, or how does that work?
For some of my clients, I do that. For most of my clients, it's not even that complicated. Basically, what I tell my clients is after we get the trust written and everything's done, call your mortgage company, let them know what you're doing, that you're going to be transferring it into the name of the trust. And I've never had anybody come back with any kind of a problem from their mortgage company at all. As long as it's a living trust and you're the beneficiary, you're the trustee, and you're the one controlling it, the mortgage company does not care.
Okay.
Hey, Charlene, really
Yeah.
quick. I actually went through and put my house in a living trust. And let's say just Chase or Wells Fargo, if you have that with your mortgage company, they will just require a copy of your trust and what it says. And then that's all the requirements that they need. Basically, they'll review that. They'll make sure that everything looks legit and everything's correct. And then they'll transfer it into the trust's name. But normally it's not very difficult. And I've never had any issues, if that helps.
Thank you. Thank you very much. And
Yeah, and a lot of times you don't even have, a lot of people are uncomfortable sending their trusts to their mortgage or their banks. And I can draft what's called like abstracts of trust for my clients. And 99% of the time if you send the mortgage company or bank an abstract of trust, which is just the first couple pages and then the last page that's signed, that does the trick. And they have no issues with it.
okay.
And the other question I saw said, what is a fair cost to pay for setting up a trust, a power of attorney, and healthcare directive? For most cases, I mean, if your estate's worth, under $5 million, $2,500.
Okay.
I do estate packages where I include all of the documents for $2,500. If it gets to be an estate over 5 million, the pricing will start going up. Or if it's an estate that's a little bit more complicated, where there are issues where it's like a special needs trust or something like that, or some people have very specific things that they want to put in a trust that can get complicated, then the fee may go up a little bit. But if it's just a typical trust where you want to set it up so that you're letting a trustee know who to distribute the property to after you pass away, then you're fine. I mean, it's usually about $2,500.
Is there added cost when you need to amend that or even revoke it?
It depends on the amendment. And it depends on which attorney you use. I mean, for me, if somebody comes to me and they want to amend their trust, and the only thing they're doing is swapping out the names of trustees, I typically will draft it and will not charge my clients a fee to do that, because it takes about 10 minutes or 20 minutes at the most. But again, it kind of depends on who you go with. If somebody comes in and they're making major changes to the trust, then it depends on what the changes are being made. But I just sort of typically look at it as, okay, how long is this going to take? How complicated is it? And then we come up with a fair price at that point. I guess there are a few people who will come in and basically, they're after a few years, they're just sort of like, look, we need like a page one rewrite. We need to redo this whole thing. What do we need to do that? And then it's just a matter of, restating what's called restating the trust, where you don't change the trust name, but you basically redo the entire trust and replace it with a new one. And that would be about the same cost that you paid to set it up in the first place, because you're just starting over.
What's in your experience, what's been like a reason for somebody to revoke the trust, like to end it? Like, why would you do that?
Oh gosh, all sorts of reasons. I've just seen people who, things go sideways with some of their kids,
Okay.
or one of the beneficiaries. A lot of times it's people who don't have kids, and they're setting, they have beneficiaries that are set up, and then a couple years later, they
don't like them
they have
anymore.
they have a falling out. They have a falling out. They don't want to give it to them anymore, so they revoke the entire trust, because they don't they just kind of throw their hands up. I don't think that's a good idea. I think it's just a matter of, okay, if change the beneficiaries. But I don't know. There's some, it could be for any reason at all. Like I said, it's up to the people who've written the trust to revoke it.
Okay.
If they want to revoke it.
There is a question here. If assets are under $1 million, does that change the price, or is that a pretty normal standard fee of $2,500 under the 5 million mark?
For me, 2,500 is kind of the standard estate plan that I charge. If you're only doing like a power of attorney or healthcare directive, that cost will get a little bit lower. I can normally do those for like $1,000, but for a typical estate package, it's $2,500.
When you are going to set one of these up, and like I have a minor child, she's only 13. She's my only, the only person I want to leave anything to. Would I have to bring the people I want set up as the trustees with me when we set up the trust?
No.
Do they need to be present in that conversation?
No, so that's a good question. They don't need to be there when you're drafting it. They don't need to be there when you're signing it. That being said, if you're going to appoint somebody as a trustee, especially since you have a 13-year-old, right? So the trustee, assuming something happens to you and the trustee needs to step in, you're not going to want your entire estate going to a 13-year-old right away. Most people want the trustee to, use their best judgment or wait to distribute things until certain things happen with the minor child. So, and a lot of people want to wait until, the kid turns 25 or 30 before they get everything. So when you appoint a trustee, especially in a situation like that, you want to make sure that you've spoken to this person, to everybody.
Not surprise.
Yeah. So and you want to make sure that they're on board to do this.
Of course.
There are a lot. I have seen cases where people will appoint trustees, they'll appoint healthcare people to be their attorney in facts for healthcare decisions and to handle their finances. And then, they never actually have the conversation with the person.
Right.
And so the worst happens, and it's sort of like, surprise,
Yeah.
you're the attorney in fact. And it's, and the person's kind of like, wait, say what? I don't want to do this. I don't have time for this. Right. And then, and then hopefully you have a backup that does want to do it and is willing to, but so you want to make sure you have a conversation with the person and they, they're familiar with what you want to have happen.
Right. Well, I have a lot of other questions, but I don't want to monopolize the questions. So if other people want to talk, please don't let me talk over you.
I'll jump. Can I jump in?
Jump.
Sure.
If I'm a first time home buyer, I would, and then one of the reasons why I don't have a trust personally is because I think I'm young and I'm not close to the age where I'm going to die yet. Hopefully. So obviously, I mean, if you're a first time home buyer, is there in your 20s and 30s, is there a case for needing a trust? I mean, this sounds like it would be for everyone immediately, right?
Yeah. I mean, look, if you own a home and it's important that, you want the home to go to someone and, a particular person, and you don't want 4% of it to go to an attorney, then the case for setting up a trust is pretty simple. I know you're in your 20s and your 30s, you think nothing's going to happen, but spoiler alert, no one's making out of this. No one's making it out of this thing alive. Everybody eventually is going to meet their end, right? That's the process of life and death and everything. So eventually it will happen. You're never going to know when. And if you have something that's valuable and you want to make sure it goes to the people who you want it to go to, you need to spell it out in a document, that ensures that happens. And more importantly, I mean, why give away 4% of it?
Mm-hmm.
Amen, brother.
Why give away 4% of it to, to a probate attorney? When you have a very simple solution kind of staring you in the face, where you
that's crazy.
Take time to write up a living trust, and it's not even going to jam you up in how you use the property. So it's like you said, you kind of hit the nail on the head as far as like why people don't have estate plans. It's because nobody likes to think about this.
Mm-hmm.
I think it's just nobody.
It
likes
sounds like a
to think
no-brainer.
about it. Yeah, but it really isn't
In
that complicated.
In terms of adding investment properties, like, assuming the trust is set up and then you buy an investment property and add, like, what's the process for adding future properties to the trust?
Same thing as putting the first one in the trust. I mean, basically, once the trust is established, you're going to transfer you're going to transfer title of the property, of your investment property, into the name of the trust.
And then in terms of the cost, there's just an additional cost for each property or something like that.
To add it to the trust?
Yeah.
No. I mean, the only cost that you're going to have to add it to the trust is going to be, the fees that you pay to transfer title and to record title. But that's about it. I mean, that's about it. And when you buy, one thing we did mention, but I guess I could mention it now since it just popped into my head, is if you're buying investment property after you already own your first home, you would obviously you're going to let the lender who's loaning you the money know that you're putting it into the name of a living trust. But there are situations where people will own more than one home. They'll have a residence and they'll have an income property, and then they're setting up a living trust. And some mortgages are written in a way where it says if you transfer title out of your name and into somebody else's name, they can accelerate the entire mortgage and you have to pay everything at once. Technically, if you transfer title out of your name into the living trust, that could trigger the acceleration clause, and they can say, pay everything, or, we're going to repo the property. I've never once seen that happen, but whenever I have people who come to me for an estate plan, I always, tell them, look, reach out to your mortgage company, let them know you're doing this, and make sure that they're, that it's copacetic with them and it's not going to cause any problems. And it never has. But theoretically, it's one of those things where I guess it could at some point.
Bill, would in this process of doing a living trust, is that also the appropriate place to do, like, say I pass away before my daughter is of age,
Right.
and the caring of her and who I want her to go to and all of that, is that we can do that all at the same time?
Yes. That's going to be laid out in your estate plan.
Okay.
And there's a living trust. There's also something that accompanies a living trust called a pour over will that makes sure that if you inadvertently leave something, that if there's a piece of property that you have, let's just say you inherit a new mansion on Monday, and you're okay, great, I've inherited this new mansion, I'm going to put it into my living trust. I'm going to do that on Friday because tomorrow I'm going to, Bora Bora, and I'm going to do it when I get back from Bora Bora. And then you get on the plane to go to Bora Bora and you die in a horrible plane crash, right? And so there's this one property that's like left lingering. It's not into the name of the trust. The pour over will actually specifies to the probate court, okay, take this property and put it into the name of the trust. In the pour over will, that's where you're also going to specify, things like who you want to be the guardians of your kids.
Mhm.
And things like that.
Okay.
Real quick, Bill, because I know we're going to be coming up on time. I want to be respectful of that. I see Bob has a question, but before we move on to Bob's question real quick, I put in the chat box your website and email to email you. So if you guys want to write that down while we're still on Zoom so that we don't leave the call without you having that. But over to you, Bob. It looked like you had a question.
Hey, thanks, Sarah.
Yeah.
Hey, I'm wondering if a married couple sets up a trust and then one of the spouses or trustee passes away, I'm thinking the other trustee may need some help administering the trust, or is there not really anything to do at that point? And then I'm thinking, like, as phase two, when both spouses pass away, is that when perhaps there'd need to be your help in kind of administering the trust? So just trying to get an idea of what assistance might be needed when you have these triggering events after the trust is already established.
Yeah, typically how it works is this. People will set up the trust where the husband and the wife are the first trustees and the first beneficiaries. Then when whichever spouse dies first, the surviving spouse steps up as the sole trustee and the sole beneficiary. And basically nothing changes. Nothing needs to be transferred. I mean, you're basically the surviving spouse just assumes control of all the property. It's theirs. Under the terms of the trust, it's theirs. So they just continue using it as they did before their spouse passed away. It makes it pretty easy. So there really isn't that much to administer at all at that point. When the surviving spouse passes away, that's when the trustee is going to step in, and who it's going to be like, it's going to be a third party, usually not obviously not the husband or the wife. And they're going to start administering the trust. That's normally when somebody needs to step in and, either hire an estate attorney who can help administer, send out the notices and let the trustee know what to do, or hire a third party to help the trustee. But until then, there isn't, before then, there isn't much that needs to happen. And as far as, the surviving spouse needing help or anything like that, that can all be spelled out in your actual trust, depending on how complicated the trust is. I mean, some people set it up where, they have a blended family, and, when one spouse dies, it's not going to be as simple as the surviving spouse just gets everything. It's going to be a situation where the first spouse dies, and then the surviving spouse will then be the remaining trustee, but will have obligations to pass out certain assets to, the deceased spouse's part of the family.
So if we were to set up a trust and then both my wife and I passed away and we had one of our kids, our adult children, as I guess the executor, or that would kind of take over, would you kind of work with them? Would that be your process, or is that not how it typically works? I don't know how involved you and your firm get in that process.
It really depends on the trustee. At that point, it's up to the trustee on if the trustee feels like he or she needs help and wants to actually get an attorney involved to help out with this and send out the notices and administer the trust, then it will be up to the trustee to appoint, to go and hire somebody to do that. It'll be up to them.
I would think there'd be some overlap with maybe the trustee's financial planner if they have one. Do you get involved with that, work with them, coordinate with them much?
With all of my clients, I always ask if there's a financial planner involved, because that's very important, because there's a lot of securities and a lot of investment things, investment accounts, things like that, where it's set up in a way that it doesn't make sense to move it into a living trust. And the only way I can figure that out is by talking to the financial advisor. So, before anything is actually transferred into the living trust, I make sure that, we have a conversation with the financial planner that they're working with.
And last question, do you ever have a situation where there's a concern that a beneficiary is not going to handle the inheritance responsibly, and that it might make sense to set up like an installment payment plan over a certain number of years? So Absolutely. You've seen that. Okay.
Absolutely. Yeah. It's very common, and it happens all the time. It happens all the time. And I mean, just so you know, you can pretty much do whatever you want in a trust. I've had people spell out the trustee is to give out certain assets to animals, to pets. And it's perfectly legal. You can do that.
I hope that's not the successor trustee, though, right? Spot.
Hope not. Yeah.
I don't know. My cat would love my condo.
Yeah, there you go.
Cat condo.
Yeah.
It's a cat condo, right?
There was that lady in the 80s, right? Leona Helmsley, where she left all of her close relatives like $1, and then she left millions of dollars to her cats, I think.
Oh, there's gotta be one. Well, Bill, we surely appreciate you joining this call with us today and educating us and challenging us to get ourselves in gear here. But I like I said, I put all his contact information down in the chat box. Feel free to reach out to Bill directly through his email. Bill, did I get that information correct as far as the contact info in there? Is that your email that
Absolutely.
you want them to? Perfect.
Yeah, absolutely. That's it.
So yeah, you can reach out to him directly with your questions. And then I hope you guys all set up a consultation with him. I'd love that. He's local in Claremont. His office is in Claremont. Do you do much remote stuff, or did people come in to you?
It's most people these days are coming in, but I'm fine. I do things virtually, just like this. There are clients who a lot of times what will happen is we'll do the first meeting in person, and then after that meeting, the rest of it will pretty much be done virtually, unless they want to come in and have a document signing at my office, which I arrange for quite often. People.
And other than those two things that you talked about getting it set up, are there any other assets or proof of assets that people need to have lined up and ready to show you when they set up that trust?
No.
Okay.
Basically, the only thing I need if somebody is at a point where they have a home and they want to set up a trust is just come in. Just come in, and you don't even have to come in, just call. Okay. Call, and we can have a conversation. And if you don't even want to come in, I can send you a questionnaire to fill out that will pretty much cover all the assets that you have. It will ask you a series of questions that will sort of help you figure out, okay, what do I want to do with all my stuff? And then we'll have another conversation about what you want to do with it. And I can start putting together drafts of the estate plan like right away, and then send them over electronically by email through a secure link, and we can do it all remotely if you want.
Cool.
Yeah.
All right. Well,
Well,
thanks
thanks for
everybody.
setting this up, Sarah.
Of
Thank you.
course. I will send everybody the recording. I know my good friend Dave Laurie just popped on, so I just texted him. I said, we're wrapping up, but I'm going to send you the recording. So don't worry. I got you guys covered, and don't be afraid to reach out to Bill directly to get questions answered and set up a consultation with him. But yeah, everybody have a great day, and we'll see you next month, the first
Thanks
Thursday.
again.
Thanks,
Bye-bye.
Bill.
Bill, appreciate
Have a
it.
great
All
day.
right.
Thanks, everyone.
See you guys. Have a good
Bye.
day.